Joining us again, criminal trial attorney and News Nation legal contributor Sara Azari on this case. Sara, thank you.
Thanks, Natasha. Good to return.
What kind of evidence is there here? Any question in your mind that prosecutors have enough to pursue a murder charge?
You know, there's DNA and there's footage that places the defendant, Momeni, at the scene of the crime. But as we followed this case, it appears that his previous defense counsel, he just now got new defense counsel, had essentially alluded that the defense here is that this was an accident or that it was in self-defense. And so merely being at the scene of a crime, which the prosecutors may be able to prove beyond a reasonable doubt, is not enough to say that he committed the murders and that he's guilty of murder. So we need to have more. And the prelim, like you brought up, establishes probable cause. The prosecution has enough to proceed to trial, but it's actually far more significant than just being a probable cause hearing. Both sides get to test the evidence and the witnesses. The defense gets to set a record for impeachment at trial, and it might be the only, frankly, opportunity the defense has to cross-examine witnesses is at the prelim. And there's a chance that a charge can get reduced. And if so, the defendant could potentially get the bond lowered or get some sort of bail. So there's a lot of significance to the hearing tomorrow beyond just the prosecution establishing probable cause.
You know, I want to follow up on something you just said, because you're right, Momeni has new lawyers who say that they are starting essentially from scratch. What are you tracking about this? Why would something like this happen, and how does it bode for him?
Well, what I read was there was a mutual decision for him to change counsel. A defendant has a Sixth Amendment right to have a lawyer of his choice, and they can switch as many times as they want, although courts try to put the brakes on when it's closer to the time of trial. But what I found interesting, Natasha, is that the defense lawyer said, we're starting from scratch. And I thought, well, you know, there's a finite universe of defenses that you can put up. Either you were there or you weren't, or you were there and it was self-defense or it was an accident or someone else did it. I mean, you know, that's pretty much it. He absolutely has a right to change his mind, change his theory of the defense a million times over until trial. Once he gets to trial, he needs to pick a theory and he needs to stick to it.
I thought this was really interesting. There is a report that Momeni was involved in a stabbing over drugs in 2005, but it did not result in charges or a conviction. Could something like that from his past come into play if this trial moves forward?
So this is a stabbing murder. So in terms of relevance, when you look at the evidentiary rules, it is relevant. And so it's not as prejudicial as it is probative, but it is very old and it did not result in a conviction. So I think that's going to be subject to a pretrial motion, what we call motion in limine, to determine whether it should come in or not. Had he been convicted and had it been in the last 10 years, it would be more likely that it would be admitted. But it's a prior bad act that did not lead to a conviction, which makes it arguable for admission.
You know, I do want to switch gears. The so-called doomsday mom, Lori Vallow, will be sentenced in an Idaho courtroom tomorrow as well. What is the likelihood that we hear directly from her tomorrow? And even if we do, is it likely to make any difference?
So typically at sentencing, we do have our clients make a brief remorse statement to the court. She, of course, has been stoic and has not said a word and has not had a lot of sympathy or empathy throughout this trial, given that these were her own kids, two of the victims. And so whether she would now speak and address the court really depends to me on whether or not the defense is going to make a presentation of mitigating circumstances being her mental state. You know, one of the telling pieces of evidence in this case, Natasha, if you remember, was the call that she made from jail to her son, Colby. And essentially she was saying that, you know, her children that she killed knew that this was the right thing to do. So this is a woman that obviously has some sort of vulnerability and struggle mentally, in that even though she might know the difference between wrong and right, she definitely believed, I think, that what she did was for the good, not for the evil. So how much of that is going to come in? She never let it come in during the trial. She controlled her defense. And if that gets to come in as a mitigating circumstance in her sentencing, then it might be a good idea for her to make a remorse statement. How much that'll sway a judge who has sat through this trial, who has seen brutal, graphic, photos of this heinous, evil murders that she committed or she conspired to commit. I mean, it's tough to move that needle. So I'm not sure anything will sway that decision.
And Sara, about 10 or 15 seconds left for this last question. She faces anywhere from 10 years to life in prison without parole, or rather 10 years to life in prison without parole. What is the most likely outcome?
I think she will get 3 life sentences without parole, and the theft charge, which carries 1 to 20 years, is going to be a wash, whether or not it's consecutive or concurrent. I think she is facing life.
Okay. Thank you for your perspective and time, Sara Azari. Appreciate it.
Okay.